now today worked through a heavy day on direct and cross. And tomorrow what we're going to be starting with is cross, and in particular, the skill of impeachment, okay? And so the second demonstration today is going to be a demonstration on a version, the model that we're teaching on how we think impeachment can be done effectively. We're going to show you that tonight. We'll give you some materials, and then you can practice it tomorrow. Before we get there, we're going to do a short demonstration on something different, which is witness preparation. And we do a lot of work this week on the skills of working with witnesses, assuming that we're in trial, and assuming that we have done that preparation ahead of time. Well, we want to spend a couple of minutes now actually talking about that preparation. And in particular, the point we want to cover is the line between witness preparation and witness coaching, and the ethical line that is the difference between witness preparation and witness coaching. There are notes available, and the line can be seen in different places. I won't read it to you or take you there, but it's in the notes, and it's Rule 4.01 and 4.012 of the Ontario Rules of Professional Conduct, similar rules in the Federation rules and in rules across the country for those of you that practice elsewhere. And the bottom line there is the tension between what I'll call the zealous advocate obligation to do the best for your client. You are there as your client's advocate, and to present your client's case as forcefully and sometimes even distastefully as possible within the limits of the law. And the other side of that is not to do anything dishonorably, not to cross the line in terms of witness coaching, obstruction of justice, tampering with evidence, etc., etc. Okay? And so how do we effectively prepare a witness without coaching them? And what we're going to do in a very short space of time, over the next 10 or so minutes, is look at four issues, four elements of witness prep. The first we will skate through quite quickly, which are the general approaches to witness prep. The second is preparing your witness on a key part of the case, when there is a key element of the case that you want to cover. The third point is, what do you do when your own witness is now changing her story? What do you do about that? And then fourth, very quickly, a word on how to prepare your witness for re-examination. The folks who are going to do this, Sandra Barton, Nick Devlin, are going to talk and then model a slice of each of those. I will introduce them and may have a couple of comments along the way. So the first issue is general approach to witness preparation. Sandra, I'm going to turn it over to you as the lawyer and your client, Nick.
So Nick explained the role of data angles, and when you're going to prepare a witness for examination, you want to familiarize the witness with the process. Many witnesses have never gone through it before, and even witnesses who have gone through it before, it's important to remind them about the process and to take them through the process in a way that makes you comfortable, that they understand how it's going to work in this particular case. So a few of the topics we will cover will include things like familiarizing the witness with the courtroom setting, what will happen, order of evidence that will be asked, the fact that there will be asked questions on both sides, their obligations to tell the truth, answer the questions. You may speak to them about making contact, eye contact, not actual contact, eye contact with jurors, with the judge, and so on, and distinguishing the difference between a direct and a cross, and explaining to them the format of re-examinations and so on. And that's, all of those things, it will take you half an hour, 40 minutes to go through that, especially if it's a witness who hasn't testified before. You also often take a witness to court so that you can see what it's like inside the court. I will do a quick snippet on what I might say to a witness when it comes to cross-examination. So I'll turn to my witness, and I'll say, so after I examine you, the other side is going to get up and ask you several questions. The most important thing for you to remember, whether I'm examining you or somebody else is examining you, is you have to tell the truth. It's important that you be forthright in your answers, you be honest about them, and don't attempt to stretch the truth. One, because you're on your own, and two, because you'll be challenged. The other side is waiting for you to slip up. And in particular, this case is going to depend on the credibility of many of your answers and the judge believing you to be an honest and forthright witness.
Ms. Barton, I'm really worried about cross-examination in this case. I think this lawyer's a really aggressive guy, and I don't really know what to expect.
And a couple of rules that I always suggest to my witnesses and what they follow is, first of all, the most important thing to do is to listen to the question being asked. Don't interrupt the examiner. Don't try to guess what the question is or anticipate it. Listen to the question. And then what I would tell you is, wait, answer. Even if you have to count to 5 in your head. And the reason I tell you that is because that makes sure that you won't jump in, and that you'll take some time to make sure you understand the question before you respond. Okay? And if you do that, he cannot put words in your mouth unless they are true. And at the end of the day, it's your job to tell the truth.
So I'm going to stop you there on that slice, and I think a couple of things. One is you heard Sandra say, tell the truth. And it's got to be the bedrock of it. It's got to be the first thing that's out, and I think that's right. And then you heard a discussion, a real discussion back and forth, much of which you may do already, but that honest, this is what's happening. Nothing in there, she's telling him what to say. She's preparing him for what he's going to face. He's going to then have to get up and do it, right? In the interest of time, I'm moving as quickly. Of course, all of this would happen in a lot more longer and more luxurious way, but I'm going to push Sandra and Nick on to the next point, which is, what about when you're preparing your witness for a key aspect of the case? And in this, we're going to talk about, in the Cooperman case, the issue is this: was Engels fully advised on the conflict issue and the potential for a reduced damages award if he did not sue Mary Rubin? And if you take yourselves to the pleadings, don't do it now, but the basic point here, for the plaintiff, Engels, he says that neither Simpson nor Cooperman ever indicated that a failure to sue Rubin could reduce the amount of Engels' damages, whereas the defendant, Cooperman, says the plaintiff was fully informed of the conflict and of the implications regarding a potential reduced damages amount if Engels did not sue Rubin. Sandra.
So, David, one of the really important parts of this case is what you were told about the conflicts issue and how that would affect your ability to recover damages at the end of the day. Now, let's take a look at our statement of claim. I just want to walk you through what we did when you first came to me and spoke about this. Remember at paragraph 12, you said, and you wrote that Ms. Simpson informed you that you had a claim against Ms. Rubin, and that you, if you wanted to pursue it, then you couldn't hire their firm. And then he said that at no time did Simpson indicate that Engels, to Engels, that his failure to initiate a claim against Rubin could reduce the amount of his claim against Acme. Now, they take a much different position. And I'll show you later in their pleadings when they do that. But what they are saying is, no, in fact, they told you everything you needed to know about the conflict issue. Here, it's really important that we go detail by detail through what you recall about what you were told and why you had that memory. So let's take a moment now to do that. And God has spoken about this before, but remind me again, after you spoke with Mrs. Simpson and she told you that there's a potential, she told you there's a conflict issue, share with me how she explained that to you.
Well, I remember her telling me that I had a case against Mary, which I thought was really weird because we're in the same car. And that if I wanted to sue her, then we had to get different lawyers. We couldn't both have the same lawyer. Now, I thought because the accident with the truck driver's fault, I was really surprised by that. I didn't know why I would be suing Mary. And she asked it. That I think about it for a while, and I said, well, I want to sue Mary because she's my friend, and the whole reason we were there is that she talked me into seeing a lawyer. So, and it just didn't seem like something I would do. And she just said, well, okay, then if you want us to act for you, you can't sue Mary. And that was kind of the end of it.
And did she talk to you at all about the fact that not suing Mary could reduce the amount of damages you could recover?
No, she never talked. Well, she never told me that I'd get less money. She said I couldn't sue Mary, right? And I guess I didn't really know what that meant.
And are you sure that she did? And this is really important because this is an area you're going to be challenged on. Are you sure that she did not speak to you about the damages issue?
Well, no, because if she had said that I was going to get less money, then I would have, I probably would have had to think about it differently. To me, it just seemed like a lot of complication we're taking out of the case.
Yeah. And it's going to be important for you not only to defend that position when you're being examined, but the detail as to why you are certain about that position is going to be really important.
Well, what should I say about that?
Well, I'm going to take you through the examination in chief, and I'm going to ask you, as you recall, they're all open-ended questions. So what's important is, I will direct you as much as I can, but you have to try to remember everything that you were told on that. And certainly, to the extent that you're certain that you were told about something, it's important that you convey that to the court. Okay?
Okay, so we see that key point, identifying the gap, taking him through it. The one thing I might have added to that, I think Sandra did this in what she just said, but when Nick said, what should I say about that? I think the quick answer might be, you got to tell the truth, and then say exactly what you said. But that's the point that's being made. So nice job taking us through that. Now, what I want to do is push you even further into now, Nick, you've got to recreate some history here, okay?
Okay, well, I remember Cooperman telling me that the truck driver was at fault, and that there was no worry about a reduction in damages because of how Mary drove. And that was, I remember her saying that.
When did she say that?
Well, it had to have been when we, I think we only met with her once. It must have been on that first day that we went in.
David, we've gone over this now 4 or 5 times since we started this claim. This is the first time you've raised that.
Oh, I'm sure I mentioned that.
No, you really haven't. Lying sack of milk.
You promised me that I made every dime back from that woman. And I will do that.
David, now, you filed a statement of claim. Nowhere in the statement of claim did you allege that. You were examined for discovery, and you were asked, and I'll take you through the discovery transcript. Counsel asked you several questions about what you recall. And finally asked you if there's anything else you recall about what you were told about this conflict issue. Your answer was no. There was nothing else that I
What did I say?
Well, you told him that you were told that you couldn't sue Mary and still retain the firm. You told them
Right.
that you didn't want to sue Mary because she was your friend and the reason you were there. And you told them that the driver, in your view, of the Acme truck was at fault, so there was no reason to sue Mary. And that was the extent of your conversation with Ms. Cooperman and with Ms. Simpson about the conflict issue.
Well, that's not really different.
Well, you've added a lot of detail, and this is important detail. Remember, credibility is everything, and it's not going to help your case to suddenly invent evidence that you think is more helpful. And I'm going to challenge you on this because this is the first time that you've mentioned it to me.
Yeah, I'm sure I should have said something about that before, but
Well, let me put it this way. I'm your counsel, and I believe in what you're saying wholeheartedly. And I'm raising my eyebrow right now at what you're telling me. I'm raising my eyebrow. There's no doubt in my mind the judge should raise an eyebrow. So we need to talk about this, and I need to understand why you think that that was what you were told at the time.
kind of what I remember. Like, I was thinking about it today, that's kind of what I thought happened. She must have said that.
All right, we're going to have to spend some more time talking about this issue because I am very concerned. We're just a few weeks before trial, and you're raising this. Now, if that is the case, we're going to have to send a letter to counsel to provide them with this information, an obligation to do so under the rules. And you can be certain that counsel is going to raise this letter and say, you were examined over a year ago, and just 2 weeks before trial, he has received a letter saying this. You understand how that's going to work to the court?
I guess I should make my name's probably best if I just don't say that.
Well, no, I mean, I think you should give me your checkbook.
So here's the key moment, right? And the challenge for Sandra is sorting out now what is becoming a conflict. Does she believe the guy? And if so, has he persuaded her that the new evidence is correct? If so, you got to correct the record. If not, if she doesn't believe him, there's a conflict in play, and she likely needs to ultimately get off the record. It's not an easy one to do, but of course, this is one client. It's not the entire career. We've got to keep the long view in mind. Easier said than done, but you can't continue to act with this conflict in place until you resolve it one way or the other. Nick or Sandra, comment on that.
So when you're preparing your witness, sometimes this will happen where a witness will suddenly develop a better memory, and sometimes it's actually accurate, and they can give you a justification as to why they remember it, and you believe what they're saying, and so on, and you can credibly support that answer. And that's not a difficult call to make. What's more difficult is when your client insists that they have a certain memory, that something happened, and you are doubtful as to whether that occurred. Being doubtful is not enough to get you off the record. Being doubtful is not enough for you not to put that evidence forward at trial. But if you are concerned about the credibility of that evidence and your witness will not waver,